Sorry. My lady, my lords, thank you. So you should have had handed up to you two more documents. I'm sorry that they are loose. And one of them is the very well-known judgment of the House of Lords in Huang, and the other one is section 85, for which I referred you to before.
We need to look at
So can I take you to paragraph? So Huang is the authoritative statement of the role of the tribunal on appeals on Article 8 grounds. If I could ask you to look up paragraph 15, and just to say, the conclusions in Huang are reiterated and summarised post new immigration rules in the case of Hesham Ali. I'm not going to take you to that, but you'll see there's quite a long section in Hesham Ali.
Sorry, what's the name of the case?
So the case is Huang.
No, the one that
So Hesham Ali is
Hesham
the...
Ali.
Yeah.
Oh, sorry, I didn't catch what you said.
I'm so sorry, my lady. So Hesham Ali is at tab 10 in the bundle.
Yeah.
And there is no suggestion at all that the role of the tribunal has changed by the time of Hesham Ali. And so Huang, paragraph 15, so it's page 185 of the report. The first task of the Appellate Immigration Authority is to, and that which would now be the First-Tier Tribunal, of course, is to establish the relevant facts. These may well have changed since the original decision was made. In any event, particularly where the applicant has not been interviewed, which applicants aren't usually, the authority will be much better placed than the Secretary of State or the Entry Clearance Officer to investigate the facts, test the evidence, assess the sincerity of the applicant's evidence and the genuineness of his or her concerns, and evaluate the nature and strength of the family bond in the particular case. It's important that the facts are explored and summarised in the decision with care, because they will often be, always be important and often decisive. So that's just that's the background to the backdrop to the role of the tribunal now. It has that fact-finding role, and then 16. The authority will wish to consider and weigh all that tells in favour of the refusal of leave which is challenged. So consider and weigh all that tells in favour, and there'll be some general considerations, and that's the first 10 lines, and in some cases much more particular reasons and some examples given. And we would say that it would be a surprising thing if the role of the tribunal in determining an Article 8 appeal had shrunk since 2014 without courts taking note of that. And we say that it hasn't. The job of the tribunal remains the same. In the Hesham Ali case, the Secretary of State had by then introduced immigration rules which related to Article 8. And again, the Huang approach to the role of the tribunal remained the same. You have my submission already. I want to deal with this because it affects many of the grounds, but you have my submission about the reasons why facts relating to compliance with the immigration rules are relevant to the decision. You have some support for that in Huang. The other point to make that I wanted to make before I come back to the ground one directly is that there is no distinction in statute or even in the arrangement of the rules themselves between Article 8 rules and other rules. Statute does not create this, the statutory regime does not create a distinction in the ways that the tribunal is expected to examine an appeal against a refusal under an Article 8 rule or an appeal against a refusal under one of the other rules. And again, if there were a thing, if there were a category of rules which are to be designated as Article 8 rules, and if the tribunal were required to exercise its fact-finding jurisdiction in a different way in relation to those rules, that would need to be set out somewhere. It would need to, and if the jurisdiction of the first-tier tribe of a statutory tribunal were to be affected by different categorisation of different types of rules, that would need to be laid out, and it's not. And we submit that that's because in all cases where a person has an uncertified Article 8 appeal before a tribunal, the tribunal is going to have to make findings of fact about the issues which are relevant to it, including whether a person meets the requirements of the immigration rules, and it can't do that without making the facts, which, as Lord Bingham said in the Huang judgment, it's better placed to make than the Secretary of State. Very different from the kind of conclusion which is not factual but entirely evaluative, like conduciveness. So I'd like to go back then to ground one. What I'd like to do is to take you first to two cases, then take you to the decision, and then make my submissions about it. The two cases are cases directly about the jurisdiction. The first one is the case of Baihinga, and it's at tab 16 of the authorities bundle. In fact, it may be that I don't need you to turn it up, just to flag up some of the passages from it to save time. So the relevant sections of it.
I can't tell whether the word's taken out of context.
My lord, so I will take you to it then. So it's at tab 16. It's a returning resident. It's not very different from the case which my lady considered in the alley case. That maybe that it wasn't quite such a.
This is a decision of the Upper Tribunal.
Yes. It may be that to save time, I'll go straight to MY, which is the case, which is the tribunal case that everyone's looking at. But the reason I was going to Baihinga is that it's the Upper Tribunal making clear that, but it's probably common ground that a human rights claim can be implied or explicit. That's clear from the Secretary.
It is common ground, and it's in the policy.
Yes, well,
it would. I think, to be honest, it would be a lot more helpful if we actually got taken to the decision and we understood what your submissions were.
But I don't think anything that's been said so far could move things on. It's what happened with the decision. What was the decision person doing?
So may I
objectively?
So may I take you to MY Pakistan and then to the decision, because MY Pakistan is it sets the framework against which I submit the decision should be looked at. So it's tab 20 of the authorities. It starts on page 374. And it's the case that my learned friend relies on and says that we are a fortiori for the applicant in MY. So this is the case where someone made an application for indefinite leave to remain as a victim of domestic violence. You see that from paragraph 2, sorry, and then and in order to do that, he uses a prescribed form. So if I could take you to page 377 of the judgment, which sets out what was the background to the claim. So there was a prescribed form prescribed for applications for indefinite leave to remain as a victim of domestic violence. That's sideline E on page 377. And the Secretary of State in that decision had adopted a form which did not allow a human rights claim to be made at all. And you see that from paragraph 22 of the decision, top of page 384. Gives applicants no specific opportunity to raise the human rights form at all. And the Secretary of State refuses the decision back on 377, subparagraph 5. Refuses, the application, but says, I have not considered your contention that removal would be a breach of your convention rights because that is not covered by your application and it was required to be raised by a separate application using a different form. So that's the decision which was under consideration in MY. And just stepping back from that and again applying the Rasgar tests or looking at that through the prism of the Rasgar tests, do we know what the Secretary of State thought of that application? The answer is no. We don't know whether the Secretary of State thought there was any family life or private life relevant. So we have no answer in that decision to the first Rasgar question, still less any decision on interference or proportionality or any of the other Rasgar questions. Just some other point, and that's the main point I want to take from that. Can I just take you to a couple of other paragraphs in there? Subparagraph, so page 378, paragraph 6. It's a point I made at the outset. The immigration rules do not recognise a human rights claim as such. But the second at the bottom of paragraph 6, but the Secretary of State recognises that some of the bases for leave to remain under the rules inherently involve a human rights claim. And without taking you through the rest of this judgment, because it's common ground, the Secretary of State also recognises that some forms of leave to remain potentially involve a human rights claim. There's nothing here which suggests that the decision-making process or the jurisdiction of the tribunal is affected by the question whether I've made an application under an inherent Article 8 rule or a possible Article 8 rule.
That's not the point that's being taken against you.
On this ground?
No. It's never suggested by the Secretary of State that there's a difference between an inherent claim and a major claim. The Secretary of State says I didn't engage at all with your question, which is exactly what was said in DV.
Really a factual question which turns on the decision. After 45 minutes, we haven't yet looked at it.
Well, we looked at it before, but my lady, the reason I took you there was to save you turning up, that it's relevant, I say, to our submissions on ground 6. So I'll take you to the decision now. But I was going to suggest that my lady and my lords have in mind the decision which was considered in MY, since it's part of my learned friend's submission that this case is a fortiori to that. So the decision is at page 306 of the core bundle. And substance of decision at page 307.
The starting point, just to keep myself orientated, your application for a visit visa to the United Kingdom has been refused. That's what it says in 306. And that's what it says in the first paragraph under heading decision.
Yeah.
I've refused your application for a visit visa because I'm not satisfied that you meet the requirements of the relevant things. So that's where we start off here.
And we know from the Secretary of State's policy and from the statute that that's not enough. What the Secretary of State says she's done isn't determinative of the issue, of the question what she has done.
Right.
So, because what we need to do is then look at what the Secretary of State has done. So, just looking at the decision, you have applied for a visa for 6 months for private medical treatment, and then there's a reference to the previous questions, which you know.
In Cairo, yeah.
The reason why it's relevant is because the Secretary of State, because of the delay which that process created, further documentation was filed, which the Secretary of State agreed to consider. That's the reason I make that point. So you see further letters. You find they're all in the bundles. I'm not going to take them to you, but it's in particular the letter of 17th of May 2024. My Lord referred to it earlier on, which sets out the Article 8 claim. And the Secretary of State says, the entry clearance officer says 4 lines up in that paragraph, all documents and information submitted as a part of your application have been considered. So that's a flat distinction between the MY, the context of the MY decision and the context of this decision. In the MY decision, the Secretary of State says, I have not considered your Article 8 claim. And then there's detail in the next paragraph about matters which go both to an application outside the rules and to the rules. The next section of the bottom paragraph on this page relates to some of the provisions of the immigration rules.
It's quite interesting to look at the letter because the third big paragraph ends with the phrase, I'm therefore not satisfied with your intention of visiting the UK to leave. She could have left it there if that's all she was dealing with, but she hasn't left it there. She's obviously moved on to doing something else, so we need to bear that in mind.
Yes, Monroe, thank you very much. You're going faster through it and more effectively than I am. So at the bottom of that paragraph, we've got the box being ticked. This doesn't meet the requirements of the immigration rules. Over the page, the next paragraph deals with the next of the paragraphs of the rules, and of course, it does refer to intention to leave at the end of the visit. That's the rule.
It's
We
again
know.
to do with the 6-month period and whether it would be long enough and so on.
Yes. So those are factors which are relevant, and we'd simply say, I'm going to come on to the next paragraph. We simply say again, figuring some of the things that I'll say in relation to ground 6 to 8. It's clearly relevant to the assessment of the public interest, whether the Secretary of State is right about that. Is this a person who's going to come, spend some money on private healthcare, or have some money spent on private healthcare and leave, or is she a person who's going to overstay?
What I get out of this, to be honest, Mr. Chirico, at the moment, is that in the third paragraph, she's looking, well, in the second paragraph, I know she's looked at the human rights stuff and bindings. In the third paragraph, I know she's dealing with the visa only under one of the rules, V 4.2a.
Yeah.
I read over and I see she's also dealing with it under something called V 7.2a2. And then in the next paragraph, she's dealing with those
Article
two.
8.
So far, she's aware of the human rights, because I'm just trying to recreate
Yes.
what she's doing. And then she's dealing with specific rules. And it's the next bit that one needs to try and work out what she was trying to do as a matter of objective interpretation.
Yes, my lord, but just going through the decision, it's important to see that the two are treated separately. So there is a by contrast again with MY, where the decision at the end of the seventh line on page 308 would say, and I see you've said you've made a human rights claim, but I'm not going to consider it. You need to make an application on the right form if you want me to.
Yeah, to be perfectly honest, I don't find much help in taking one case which involves one set of facts and looking at one paragraph out of context. To be blunt, I find it much more relevant to try and work out what the decision maker said here. I doubt the decision maker had ever heard of MY. I doubt she had it in mind, but even if she did, she hasn't mentioned it, so I'm just looking at the words that she uses.
So the next paragraph.
The letter says, Article 8 is relevant. I have considered statements made by Bindmans, and I am satisfied your application is not capable of engaging human rights, and therefore a human rights claim has not been made.
So two observations on that, Melody. First, we know that was wrong. Just as a matter of agreed position, we know that it was wrong to conclude that a human rights claim had not been made. We know that a human rights claim.
Sorry, you're going to have to speak up, Mr. Chirico. I can't hear a word of that last sentence. You really are going to have to speak up.
So, my lady,
Thank you.
we know that the conclusion that a human rights claim has not been made was wrong. It's common ground that was not correct. That's the first thing I'd like to say about that. The second thing is that we have to decide what the Secretary of State means when she says your application is not capable of engaging human rights. As if what, and that's what this turns on. And I'm sorry if it's taken too long to get to that, but that is what what does the sentence or the phrase "your application is not capable of engaging human rights" mean? The Secretary of State or the Entry Clearance Officer goes on to explain and says to engage Article 8, and as my lord said, that's not necessarily a helpful way of putting it, but to get, and I would reformulate that as being to answer the first Rasgar question in the affirmative so that we have to move on. A claim must demonstrate a family relationship in the meaning of Article 8. That must be what this means. So I'm saying, if you want me to grant your Article 8 claim, you need to show that you engage Article 8, and in order to do that, you have to show that you've got family life in the meaning of Article 8. That's all that.
So the short submission is that this particular paragraph is going through stage 1 of Rasgar.
So what my short submission is that whatever the Secretary of State, whether the Secretary of State says she's relying on a policy or not, what she's actually answering is the question, is this family life in the meaning of Article 8? And she's saying no. And she may be answering a slightly different question, which is this family life such as could enable you possibly to win a visit visa or to be granted a visit visa application? But it comes down to
I just wonder if she's saying, I've got this letter on the desk, I've got to answer it. This letter is saying this person has got this Article 8 claim. Gosh, what on earth do I do? The guidance says, oh, if it's not one of these, it doesn't qualify. That may be all she was trying to do. The labels she then puts onto that exercise is neither here nor there, because we will have to decide whether that meant she was trying to deal with the claim and she was refusing it, rightly or wrongly, but she was trying to engage with the claim rather than saying, I'm not going to consider this claim because you don't even get into the ballpark of whether it's a human rights claim or not. It looks as if she's just saying, I've got a problem, I'm applying the guidance, and you don't qualify. That seems to be what it's saying.
But so the entry clearance officer is applying guidance which is intended to tell her the answers to questions about the Human Rights Act. The purpose of that guidance is to say, has a human rights claim been made?
Yes.
What do I do with it? And the particular thing that's it's part 3, isn't it, of that guidance tells you is, unless you are one of these people, you don't have family life. And therefore I say, in reliance upon the guidance, I can't be separated. I'm adopting the guidance by making this decision. Secretary of State's guidance can't be separated out from the ECO's decision. The ECO is, sorry, my lady.
I would agree with that.
So what the entry clearance officer
She's applying, or he is applying the guidance in order to determine whether, in the mind of the entry clearance officer, there is in fact a need to go through the RASGAR credentials. You say that irrespective of the way in which this is expressed, in substance she's gone through RASGAR without intending to.
So in substance, she or he has gone through RASGAR 1
That's
without
the point.
intending to, and doesn't therefore need to go further. Because she says, well, this is not a protected family life, either generally or for the purposes of a visit visa application, I'm not going to decide any more.
And it just raises this point: at what stage can you? Does the entry clearance officer, if the entry clearance officer doesn't want to engage with RASGAR, simply have to say, I am not dealing with this claim, full stop? Because any attempt to apply the policy guidance is immediately going to get you into the situation where a human rights claim is being made. That appears to be the logic of your submission, which is the minute that you start to engage with the question of whether or not the relationship falls within Article 8, you're immediately deciding RASGAR.
Well, that must be right. Well,
Yeah, I think it must be, as a matter of logic, that must be your submission. The moment anything is said to engage with whether or not this is the type of relationship that would potentially engage Article 8, an Article 8 claim is being treated as having been made.
So an article claim is being decided. An Article 8 claim is being decided. Someone is making a decision. So let's imagine that I've said I have family life with my 5th cousin who I've never met before, and I can't remember their name. The answer to that question is, well, that's not protected family life, and and I'm certifying this claim. No reasonable judge could conclude that a 5th cousin I've never met before.
But it's got to go to a judge, unless it's certified. Unless it's certified.
But the certification process is the answer. That's
but forget the certification process. The point is that immediately engages a right of appeal subject to certification. That's your submission.
Yes, it is our submission. Because the question what Parliament has said is that the right of access to the tribunal depends on a decision having been made, and we have to look at whether a decision on an Article 8 claim has been made. And the decision that you might what the decision maker is doing here, just stepping back from the whole of that paragraph, is saying, I've seen your human rights claim, I have considered it, and I consider that refusing entry clearance would not breach your Article 8 rights.
Saying, I don't believe that we're in Article 8 territory. You actually put yourself in Article 8 territory. That's more or less what it boils down to. So the decision maker says, I don't think that this is a case that engages Article 8. That gives rise to a right of appeal on the basis that it does engage Article 8, or it arguably does.
Well, no, it gives rise to a right of appeal on the basis that I have decided whether it engages Article 8. And the right of appeal comes from the fact that I've made that decision, Molly. But I would agree with that. As I say,
that's a question of interpretation of this particular paragraph and the next one.
Molly, can I just say there are 2 other ways. So the reason why it is useful, just to have in mind the MY decision, is that you can see another thing which could be done. This decision maker could say, no, come back to me with a different kind of application on a different form. I'm not going to look at this, and hasn't done that. And that's why we say that that the answer to the question, stepping back, has the claim been decided substantially, must be yes. The claim's been decided and the decision maker said, I've got a policy which says that you're not the kind of person who can ever win and therefore you don't win.
Well, you know, looking at the guidance at 480 of the authority study, 24, third question, and it's, I know it's on the track record, it's the word capable of engaging human rights. It's so meaningless because the answer they give it a 3 is wrong. If the question is, are these matters such as to involve a breach of Article 8.1 and interference within 8.1, which is what capable of engaging human rights means. And it may not be an interference for a number of reasons. It may not be an interference. It may not be a family life. But when it says 3, if no, then refuse the claim with no right of appeal. Logically, you say that can't happen.
Yeah.
Once you're actually addressing, does this person fall within Article 8.1 or not, for whatever reason, you are deciding a human rights claim. I think it comes down to that. And then it's the question of what you're deciding to do.
Yes, well, I'd agree with that. And so there is a difficulty. I think my own friend recognised it in a policy which says, which says that it's so it's page 483 where that question, my lord, is then is then particularised, or the approach is particularised on 483 onwards. You have a policy which says that it's dealing with the question whether the matters raised are capable of engaging human rights, and says if the answer is no, you say that you haven't made a human rights claim. That can't be right.
Well, what you're saying is that whichever way you answer it, you've already started to make a decision.
Yes.
Or you've already made a decision. Because it's part of the decision is by deciding that Article 8 is not engaged, you are actually making a decision on an Article 8 claim. That's really what it all boils down to.
And if you look at the decision, second paragraph on 308, you can almost put to one side the last line. It's interesting what the ECO thinks, but she can't decide whether there's a right of appeal or not.
And stepping back again, we know why this has been refused. It's been refused because an entry clearance officer has thought you don't have family life that's relevant to this application. So that's the Rascal question. But yes, my lord, I would agree that what the entry clearance officer thinks that she or he has done is neither here nor there. We just look at what the effect is of what has been done. My lady, my lords,
there's also another paragraph that helps you, does it? The next paragraph, the additional information provided by binders on the 17th of May, that was the one I referred to this morning, states that they are of the view that discretion is appropriate and should be exercised in your case. It has been considered whether the particular circumstances set out in your application constitute exceptional circumstances which might warrant a grant of leave to the UK, read in context, that can only be Article 8, and even though you're not a genuine visitor, you're not going to go back, are there exceptional circumstances outside the rules and still in Article 8?
Well,
does it not?
I'm not sure it does, because it could be read as being a qualification to the refusal on the basis that she doesn't meet the requirements of paragraph 5.
One thing I think is pretty clear, this letter is pretty unclear.
Well, yes,
But what it is quite unclear, and it's probably in part unclear because the policy is so unclear.
You're telling us that the policy is plain wrong.
Well, I'm telling my lady and my lords that you don't need to decide whether the policy is wrong.
Well, yes, but look, we can't not grasp the nettle. Yeah. If you are right, the policy is wrong.
Yes, that's probably correct.
I think your case really is that in substance, she had a set of factual submissions about why she ought to be allowed to come here, which was said to involve a breach of Article 8 if they weren't adhered to. The mental exercise that the decision maker has gone through is considering at least part of that by asking whether the relationship is such as to be encompassed within the right to respect for family life. She's come to the conclusion, because she's applied the policy, that it doesn't.
Yeah.
She sought to say that means it's not a human rights claim. Interesting, but she doesn't decide that. Yeah. We do. And she has decided. That's your real case, I think.
My lord, my lady, that is our real case. And we say just one more thing. It matters not whether she's reached that decision or he's reached that decision by reference to a policy. It's a decision that's been made. That for whatever reason.
Just make a note of that.
Yeah.
I think a lot of them does come down to this capable of engaging human rights. It's just misleading.
Yes.
She's decided it's not within Article 8.1 because she's not satisfied about the nature of the relationship.
Yeah.
Yes.
It's not quite the first Rasgar question, as framed in Rasgar, which is whether there's an interference,
Yes.
which is a separate question from whether your claim falls within the scope of the right. But I'm not suggesting this matters, but it isn't actually.
No, it's
But it's Mr. Malek's point about it being a prior question when you're looking at the face of the policy on page 483, and what the caseworkers are being told, rightly or wrongly. A human right is engaged when the basic elements of a claim are made out. For example, in order to engage Article 8, the claim must demonstrate a family relationship, and the relationship in question must be one that is capable of engaging the right to respect for family life. Now, it may or may not matter, but the minute, on your analysis, the minute that a caseworker starts asking that question, they are deciding a human rights claim.
yes, well, and just in response, that is our answer, and it could be said that the policy is also trying to determine whether there are certain categories of family life which wouldn't be interfered with by a refusal of a visit claim. But again, that's all part of that would all be whatever the policy is trying to do, and it's not terribly clear. You're still answering a Rasgar 1 question. So I would accept that Rasgar 1 asks a slightly more complex question than that, but that's still the question that's being answered here.
I think the fifth point, one, a factual set of submissions saying a refusal was a breach of Article 8. 2, those were actually considered. 3, it was decided it wasn't within Article 8.1 because she wasn't satisfied about the relationship. 4, she then went on to refuse a visa, but she wouldn't have refused a visa if she thought it was a breach of Article 8.1. So she is, whatever she describes it as, she's trying to decide, will I have acted unlawfully if I don't give this woman a visa because of what they say about Article 8?
And that's why it's important to distinguish that from the kind of decision where what the Secretary of State actually says is, I'm just not going to look at that question now at all. My lady, my lords, I'm subject to you having any other further questions. I'm aware of the time, and I would those are submissions I'd like to make about ground 1.
We were thinking we didn't need any assistance on 2 and 3, which we understand to be solely whether the Upper Tribunal was in error by saying we're setting the whole thing aside, we're not going to hang on to the findings below, and so we don't think we need any assistance with 2 and 3. That helps on time.
I'm very grateful, and I hear that with gratitude. I'd like to just say one thing, which is simply to draw your attention to one other case, which is in the supplementary bundle, which is the case of Rajaratnam. But I think you may not even need to look at another case if you don't need to hear from me.
If you want to take us through anything, I mean, we can't do more than help you, Mr. Chirico, but if you want to take us through something.
No, I think I will leave it. I'll leave it. I'll there's no. We'll end up spending a quarter of an hour on something from you don't need to hear from, and I will take that with gratitude. So I'd like then to move on to grounds 4 and 5, and in order to do that, I'd like to spend a little bit of time on the facts of the case. I'm very aware that you're familiar with the facts of the case, but just because there was some discussion about what the purpose was of this visit, and also the nature of the claimed family life. If I can quickly refer you to some of the documents.
We're not the first instance, we're not even the second-tier tribunal, we're the Court of Appeal. Are any of the facts in the remade decision wrong?
No, but there are no.
So we don't need to go beyond the decision then, do we?
Well, there are maybe 1 or 2 elements of the elements of the witness statements which go beyond what's in the decision. That's but I'm not going to spend long on this. Can I just identify the documents which were most relevant? And I will be as quick as I can with this. So the first witness statement of the sponsor, which is in the supplementary bundle, I'm not asking you to go through it. Can I just refer you to some paragraphs? So 90 pages, if you are looking it up, so pages 97 to 98 I'm going to summarise this very briefly. So what is set out here is the background to family life, the particular role which the sponsor has in the life of her mother, and the evidence which is consistent throughout the witness statements of the sponsor and also her oral evidence, the evidence as to why her relationship with her mother is closer and more detailed and more important to the health of her mother than other family members. There are references to the way in which the appellant communicates with the sponsor in ways which she doesn't communicate with any of her other family members. I'm just going to give you a couple of references, if I may. So there are
65 and 66 of the actual decision, the information about her suicidal thoughts, her
yes.
financial information, her private information, and the fact that the bond between the appellant and the sponsor is stronger than that between the appellant and her other adult daughters.
Yes, so, and then, well, yes, I can see that page 98 of the witness statement, sorry, page 98 of the supplementary bundle, paragraph 18 of the witness statement. I think of myself as the mum in the relationship, really. I've always said that to my siblings. I feel it's my responsibility to look after. I always have. And the only point I'm making is that all of this evidence is accepted, and it's evidence which is capable of showing something more than the usual emotional ties between an adult daughter and her mother, and it's capable of pointing towards elements of dependency. And there are explanations for that within the witness statements, for instance, on page 99, 19 and 20. On page 163 of the same bundle, you have the third witness statement. And page 232, paragraph 5 onwards. And the point I would make is that despite the fact that the appellant is in Gaza with her family members, the person who she tells when her health deteriorates and she has an onset of ill health, I don't want to speak about it in more detail, but which plainly directly impacts on her dignity. The person who she speaks to is her daughter in the UK. It's only after speaking to her that, and you see it over the page on 164, paragraph 11, that she's able to persuade her mother to speak to the family members who are close by and able to do something directly to assist. Again, the point I'm making is that that is something which firstly distinguishes this sponsor from the other family members who are in Gaza, and secondly is capable of showing more than the normal emotional ties and specifically additional elements of dependency. Because in my submission, the tribunal was plainly entitled, and we don't have to say more than that, to treat this kind of evidence as showing that the appellant has additional levels of dependency upon her daughter in the UK. If something awful happens to me and I find that I'm suddenly I'm losing my dignity, who do I rely upon? Who do I depend upon to assist me? Who do I depend upon emotionally? Who do I depend upon to sort things out? I depend upon my sponsor in the UK. And those are the kinds of bits of, and it is important to look at the texture. The Upper Tribunal decision is detailed in its findings of fact, but it doesn't give all of the texture of the evidence before it, of course. And then, just while we're within the witness statements, and this is in answer to a point which will arise later, but on page 99 of the supplementary bundle, so we're back in the first witness statement. My learned friend made the point that it's part of the appellant's case that her daughter can't go and spend time with her in Gaza. It goes on to make a submission about how do we say something different about the appellant. And you see on this paragraph why it is that the sponsor is not able to leave Gaza. We've asked for the organisation she works for not to be identified in court as part of the anonymity order. I don't know if you can see it at the bottom of paragraph 23, but she explains why it is that, as has never been challenged and as is accepted, she has not felt able to go back to Gaza. And then you also see the reasons why it's been difficult for them to meet anywhere else. It's also extremely difficult for the appellant herself to get out of Gaza. And then still on that page, and we said this is very important because it shows why the proposed visit to the UK is not just about coming to get health treatment. It's about coming to get health treatment and be mutually supported by, and to be supported by my daughter, and mutually to support her. We see what's happened in the past. So really quite short, barely a year before the present conflict or the recent conflict in Gaza, the sponsor took 3 months off her work in order to be able to go and spend time with her mother in Jordan. Now, that the appellant has another daughter in Jordan. They spent every possible moment together during that period of time. And you see other things, and you'll have read them over the page. But we say it's important to see that this is a family which have already decided that while the appellant, when she's having to undergo medical treatment, that it's very important for her to be with her closest daughter. The daughter with whom she speaks about things that she can't speak about to anyone else, and so on. And my Lord would like me to focus on what's said by the Upper Tribunal. Can I take you to a passage in the Upper Tribunal's fact finding? And that's on page 126 of the core bundle, paragraph 89 of the Upper Tribunal's.
79 is a bit
89, so it's page 126.
79 is where they say the sponsor provides her mother with emotional support. She shares with her private and intimate information, which she does not share with the other children.
The only reason
All
that,
there.
my Lord, it's not all there, because the reason I'm saying it's not all there is you can't see, without going to the witness statements, exactly what kind of private information. It's private information about
Well, we know, we've read it. We've
about
read
loss of
it.
dignity.
We don't want to say it in court. We don't need to say
No.
private things in court.
No.
We've read it.
Well, absolutely, but do you so in my submission, it's important to see what underlies matters that also aren't included in this judgment. That this is a publicly visible document. So I just wanted to take. I'm very nearly at the end of what I want to say. Paragraph 89. What's this visit about? Now, it's important that in the judgment, in my lady's judgment in Ali, you looked at a definition of developing family life or developing private life in that particular case, and looked at the definition, which in the context of Abbas was plainly correct, which was that in that case, development, someone who's never been in the UK and comes to the UK to develop something which doesn't exist. In this context, develop is being used in a different, with a different meaning. It's an alternative dictionary meaning, which is to develop something which already exists, to make stronger or deeper something which already exists. And we know that because we know that the tribunal is finding that there is already family life. So if the appellant is permitted to come to the UK, she will benefit from treatment from her back, her mental health will improve. So that's the medical part of the claim. And she can live in dignity for a temporary period of respite. The appellant and sponsor will develop their family life together, providing each other with emotional support and care. And so the only other part of the evidence that I wanted to flag up now are the two Sarah Hecker reports. I'm not going to take you to them. You're absolutely right, my Lord, that they are taken into account in the judgment, but they do make clear repeatedly how important the well-being of the appellant is to her daughter, and the level, the extent to which she feels responsibility for that. So that it's not just that she is worried about a pen friend, and I absolutely understand, and I'll come back to that in response to ground 5. She's worried about the person for whom she feels responsibility, because within her family, she, as the person who doesn't have children, has been treated as and has taken on the role of the mum to her ageing mother. That's the family relationship which we say and I'll come on to it, we say is very significantly distinguishable from the family relationship in IA and others, was plainly capable of meeting the requirement of additional elements of dependency, and which would be important to the sponsor's medical treatment, because if she's going through difficult medical treatment and intrusive medical treatment, she wants to be doing that in contact with and in the company of the person who is closest to her, her family member. So that was what I wanted to say about the evidence. You have it before you otherwise. But my learned friend deals with ground 4. So the Upper Tribunal erred in concluding that family life and the meaning of Article 8 existed between the sponsor and the appellant, and he looked at 2 broad sets of authority. One set is the set of authority about additional elements of dependency, the test for family life between adults, and he took you to that through IA and others. I'll come to that in a moment. But secondly, he makes a submission that there is binding authority on the kinds of family life which can be relevant or which can require substantive consideration in a visit visa context. And he referred to 3 authorities. And he says in his skeleton argument that the Upper Tribunal's conclusion that Article 8 is engaged in the present case is inconsistent with those binding authorities, inconsistent with Abbas, Fopoy and Honora. And so if I can spend a little bit of time taking you to those 3 cases, and my submission will be that there is no inconsistency between the decision of the Upper Tribunal and the ratios or the decisions in those 3 cases.
Before we get to there,
Yeah.
the key and fundamental problem is they've adopted the wrong test. If they've adopted the wrong test, we'll have to start again. If they haven't adopted the wrong test, that's fine. So one of the things that Mr. Malik used to shore up his argument were these COI, whatever they call cases, the 3 ones, the one about the woman from Sierra Leone and so on. So isn't the logical place to start with whether the test is wrong? It's up to you, but logically, if they've got the right test, then that's the end of it. If they've got the wrong test, then we have to look at the other things.
So
Face of it looks as if they've applied Pythagoras, which is now not right.
So
But this isn't appeal against their decision, you see.
my lords, yes, so in that case I'll take you to the IA submissions first, and then to
Make more sense.
then to the visit visa cases. Just to be clear then, it's of course common ground that the law about family life between adult family members was clarified in IA and others. There was a line of authorities which started with Kogarthas, but more importantly was resolved in the case of Rai and ECO, and then in Udin, where it was suggested that the case or the test of real, committed and effective support was interchangeable with the test of additional elements of dependency. It's really at the Rai stage that becomes law, and that's and of course we accept. And I'll take you quickly through IA, but of course we accept that the consequence of IA is that the test of real, effective and committed support is not the final test.
Not the what test?
Not the final test. It's not the test by which a decision maker should decide whether family life exists between.
Not the test, no.
Well, the reason I'm saying not the final test is there is a specific finding that it may be a relevant step on the way. And okay, so there's no suggestion that the suggestion that tribunals should avoid ever talking about real, effective and committed support is expressly rejected by the Court of Appeal.
The test is additional dependency. There are a number of ways to measure it. A way along the route to get to additional dependency may be to look at real, committed and effective support. But
So
if
of
we
course
use that phrase only without any reference to additional dependency, aren't we likely to go wrong?
So my lords, my lady, it's quite likely that if you made a decision, can I take you through it? The answer to that question is paragraph 16 contains an incorrect statement of the law. I accept that. The question is whether reading that in the context of the judgment that matters. And our submission is that it doesn't. And there is a clear distinction between this case, in which the tribunal found both dependency and real effective and committed support, and the case of IA, where the First-Tier Tribunal expressly found that there was no dependency. And it was for that reason that the reference to real committed and effective support was faithful in the IA decision. And if I can take you through IA, so you've been there already, and unsurprisingly, and then I'll take you back to why I say that the decision saves itself despite the reference to the wrong test. So through IA is at tab 23, starts on page 438. So, as you will, you've already been told some of the relevant facts. Just a couple of other relevant elements is that the First-Tier Tribunal in that case had found that family life does exist between IA and the other 5 applicants and the sponsor in the UK, but had dismissed the appeal. I think my learned friend said that the appeal had been allowed. It hadn't been allowed at first instance. It had been dismissed on proportionality grounds. So the appeal to the Upper Tribunal was the applicant's appeal, and the Upper Tribunal upheld the findings of the First-Tier Tribunal without making any further fresh findings of its own. And as you can see from the very end of the decision, I don't need to take you there now, the Secretary of State had in fact, by the time the matter came to the Court of Appeal, the Secretary of State had agreed to grant entry clearance to the family. And so the appeal was, the whole of the appeal was strictly academic. It was pursued with indemnity protection for the applicants in that case. But it does help to explain why there was no application that the matter should be remitted. There was nothing to remit back to the tribunal. There was no ongoing relevant appeal that was relevant to anyone at all. And I'll go on to deal with remedy later on. But we say that's one of the fundamental differences between this case, which continues to affect the appellant, and therefore needs to be assessed at some point by reference to circumstances today. And the case in IA, where there were no circumstances today, there was no longer a refusal of entry clearance to be appealed from. So you were taken to, my learned friend took you to page 444, paragraph 10 onwards. And I don't want to take you back over paragraphs you've already been taken to, but just to make a couple of observations, because everyone's moving through this judgment quickly, and it's important to see not to put glosses on it. So the conclusions of the Court of Appeal in IA are set out are summarised in paragraphs 10 to 12. And it's important to see that there was a hard-edged submission made in that litigation that people outside the UK, even if they were family members, were not rights holders at all. And that was a submission which appeared to be being made at one stage in the initial application before IA was handed down, in this case as well, not rights holders at all, and that was rejected by the Court of Appeal. So there's no suggestion that the appellants, in this case, were without any Article 8 rights of their own. They do have Article 8 rights of their own. The reason they have that, the reason they have a jurisdictional peg, it's not just the sponsor who has the jurisdictional peg. They have the jurisdictional peg because they're part of the family, which has one toe or one foot in the United Kingdom. And that's important. So paragraph 11 does not say the court is looking only at the Article 8 rights of those persons within the jurisdiction of Article 1. It's saying primarily. So there's a focus on what's happening to the sponsor, but everyone has a right. We don't need an Alscaney exception. The existence of a family which is partially in the UK means every member of the family has an Article 8 right. That's what paragraph 11 said. And then in paragraph 12, and my lord had this point later on, in fact, there's reference to very exceptional or compelling circumstances in paragraph 12. The Court of Appeal wasn't suggesting that must be a test in every single entry clearance application. That's because these are outside the rules, my lord, thank you. Then going to another paragraph you were taken to, it's page 450, paragraph 40. Sorry, it's 452, I apologise. And we're in Kamari here, so we're in the recent Strasbourg judgment, paragraph 39. And I wanted to emphasise, because I'm not sure that it came across, there are reference in paragraph 39 that the references to types of state of health of an applicant and whether those would be evidence of additional elements of dependency. And remember that the test is always that. And it's important to say none of those were sufficient in itself, and I'm not sure that in itself came across entirely in my own friend's submissions, because it's important that there may be multiple reasons why a person is dependent or has additional elements of dependency. And there was a submission made in the Court of Appeal that it was necessary to show exclusive or entire dependency in order to be able to meet the threshold. And that submission was rejected in the Court of Appeal, and you can see that from page 465, paragraph 125. Sideline E. So exclusive dependency is not always required to establish family life. Rejection of a submission made by the Secretary of State. Moreover, whilst one person being completely dependent on another might normally satisfy the additional elements of dependency test, it's not the only way the test can be satisfied, as the cases we've cited demonstrate. And it's important that we don't set ourselves, or we don't require the tribunal to have set itself a question of is FA totally dependent on this sponsor? Has she got no one who can look after her day to day in Gaza? Because that's not the test. That would be an incorrect gloss on the test. You were taken to page 460, paragraph 97. I think maybe. Important to emphasise that Lord Justice Burnett is speaking specifically about extending Article 8 protection to Article 3, so outside Article 8 there. He's not saying anything about the circumstances in which Article 8 might create rights for a person outside the UK, and it's not, that section of Khan can't be glossed out, or sorry, that section of Abbas can't be glossed out by removing reference to Article 3, we say. And then paragraph, so on page 461, paragraph 100, again makes clear that the rights that a person outside the country have under Article 8 result from them having a toehold in the UK. And as, again, referring to Ali, because in the context of private life, so my lady's judgment in Ali, the toehold can be because I have family who are already in the UK, or because I have a private life already established in the UK, which I don't have to develop from scratch.
You wouldn't have a toehold if it was private life entirely outside the UK. That's what we decided in Ali.
My lady, absolutely. So, because I'm going to come on to this, I'm dealing, as my learned friend did, I'm dealing at this point with bits of IA and others which
Yes.
are relevant to both grounds. So this is going to be relevant to my response to on ground 5. looking then at, again, at paragraphs that you were taken to, page 465.
Presumably, we are bound by the findings of the decision 116 to 125. So we just apply that, don't we?
Yes. So what you, I can short circuit this. You apply the test which has been approved. So what the court decided in I and others is the test is additional elements of dependency over and above normal emotional ties that can't be glossed away by rewriting it as being real, effective, and committed support. But what it also said at paragraph 125, and we say importantly, is don't look for factual precedents. Don't look for factual precedents. The Court of Appeal rejected an attempt to find factual precedents in Strasbourg authority, and it plainly wasn't intending to create a factual precedent itself. You're taken to paragraph 142 on page 468. I don't think I'm going to waste too much time on this. So can I just? Those were my responses to some of the paragraphs that you were taken to by my learned friend. Can I then take you to page 465, paragraph 123? So we're within the section, my lord, that you just, as you pointed out, which is the binding section of this judgment. Paragraph 123 is important. It probably should be read alongside 122. So page 464. The real effective, committed, or effective support test is not just a rewording of the additional elements of the dependency test, it's a different test. And you can see why. But you can see that the practical way in which the court is looking at this, is there actually a finding of effective dependency? Is there a finding of serious dependency? So paragraph 122, because if there is, it may not matter that the test of real, effective, and committed support is used. And we can see that in paragraph, so that's the context. Then the next paragraph, 123, it would be going too far to say that it's wrong to test whether additional elements of dependency by reference to the real, committed, or effective support provided. So a finding that there's real, effective, and committed support provided may well the irrelevant part of a finding that there are additional elements of dependency. But it's not, it can't replace the test itself. And going down to paragraph 128, following that up, so on the same page. And this is the Upper Tribunal's error when it referred to the real, committed, or effective support test. Again, against the background of a preserved finding that there was no dependency. And it's important distinction between the facts in IA, or the whole concept of IA and the context of this case. Finding of no dependency. And you can see this over the page. The FTT had expressly held that the support test was a lower one than the dependence test, and there was no need to establish dependency. And it went further and said there weren't elements of dependency. And then at the bottom of 128, establishing real, committed, or effective support by itself may or may not be sufficient to establish additional elements of dependency. So it may well be that the answer to the question, is there real, committed, or effective support? A positive answer to that question may establish additional elements of dependency. So, and we say that's what happens when in this case, when it's read in context. So then to go to the Upper Tribunal's decision, and the reason why we say that the misunderstanding of law was the reason I wanted to say that it was the Upper Tribunal understood the law as it was as it appeared to be, as it was generally understood at that time. It can't be blamed for that.
Yeah.
So I'm in the core bundle Upper Tribunal decision. My references. And we're at 112, so the substantive decision starts on page 112. The entry clearance, just by way of background, of course, the Upper Tribunal reviewed all of the evidence that it was required to. The Secretary of State doesn't suggest there was any evidence which it overlooked. She makes some submissions about, sorry, the entry clearance officer, I should say, the entry clearance officer makes some submissions about important parts of the evidence, but doesn't suggest that they were overlooked by the Upper Tribunal. And then directs itself, so sets out its understanding of the law between the law about family life between adult family members, starting on page 114, refers to the Rasgar tests, refers to Mobeen, which was at that time it was a decision of the Lady Chief Justice, as now is, and was commonly used, as you'll see as well from other cases about family life between adult family members, as summarising the law, 44 to 48. Directs itself to EM Lebanon, the passage that I took you to earlier on, that's paragraph 14, and then specifically directs itself to Kamari and summarises it. And I think my learned friend doesn't dispute or doesn't criticise the summary of Kamari. If I'm misremembering that, I'm sorry. If there has been a criticism of one of the elements, I can't remember which it was. We say that that's an accurate summary of the important principles to be derived from Kamari. I think it may have been taken from my own friend's submission. And then we get to paragraph 16, and that's the point at which we accept that, as a matter of wording, the Upper Tribunal gets it wrong. Because on no view, post-I and others, is it correct to say that the test is whether there is effective or real or committed support? We accept that must be the case. Goes on to say there's no real distinction between the positive obligation and the negative obligation. Can I say that we don't? We've addressed that in our skeleton argument. The Secretary of State doesn't have permission to run that one, but in any event, you'd no doubt hear it anyway, because it's a point of hard-edged law, so I'm not trying to take a procedural objection to it. But we say that there is high authority for the proposition that there is not a real distinction between positive obligation.
Depending on the circumstances, I think the case is safe. But when you're talking about private life, and when what is said is the person who has a private life in the United Kingdom is mentally unwell or mentally stressed, or whatever phrase you want to use, such that she requires the presence of somebody from outside the United Kingdom, then that does seem to involve, whatever label you use, positive obligation is helpful, a different set of considerations from those that apply when you're removing somebody in the United Kingdom.
So we say that the correct approach to both is that a fair balance has to be struck, and that when you're striking
You have to see if it's Article 8.1 first of all. There has to be an interference. And isn't there no interference? Nothing has changed about the private life of the person concerned. The state has not done anything to make that better or worse. It's got worse because of events, in this case in Gaza. What the state is not doing is granting somebody permission to come here when the person here says, I'd feel better if they are able to come. That seems a different question, interference in Article 8.1.
So, my submission is that whether it is a different question, the answer to it is found, or the way in which the two circumstances are distinguished is at the proportionality stage, not at the Article 8.1 stage.
So everything's an interference then? I want my pen pal to come here and I'm told I can't have him here, and I thought, well, that's very upsetting.
So if it's
got to be a meaningful one.
well, so no, but clearly not everything is interference. So removing my lord, if I may, your lordship's not that example doesn't assist. So let's imagine that my pen pal is here. He's not in Australia. He lives in Newcastle. I don't see him very often, and the Secretary of State wants to remove him. And I say, oh, but that's a significant interference in my private life. Fair balance will need to be struck. If he's in Australia and he wants to come here and he's refused, I can try my best to say, well, that interfere with my Article 8(1 rights. Question about whether that would engage, whether the remedy for that would be a tribunal appeal or a judicial review. I'll come to that. But
the interference, if somebody's in Australia and I'd like him to come here because I'd like to see him, because he's my pen pal.
So the interference is the refusal of permission to admit him when he asks.
It doesn't interfere with your private life. It doesn't interfere with your private life in the slightest. Your private life is still conducted in the normal way. Just because you have the desire to see somebody doesn't mean that it's an interference with your private life.
No, but that's because we're dealing with quite an absurd example, and I understand why, a deliberately absurd example. But the question is, does it make any difference whether this is a removal? The positive, negative question is the question: does it make any difference whether this is a removal of the person in the UK or a refusal to admit someone to the UK? And we say that there's high authority for the proposition that it doesn't. It may make a difference to. I'll take you to the authorities in a moment, but we say that it will obviously have an impact on where the fair balance will be struck. But the answer to the question is that a fair balance needs to be struck, not that there is no.
The aspect of the personal life that the person has in the United Kingdom is interfered with.
Well, it would depend on the facts, wouldn't it? On that particularly absurd example, but probably not very much.
Still something.
Well, I'm simply unable to deal with a hypothetical factual scenario at that level of abstraction. It depends how. What do I know about this pen friend? It depends. I'm not sure that the example is. If I can say so, I'm not sure that the example assists. It'd be more useful to deal with an example such as: what if I've got married to someone who lives in Chile and I live here? Is there an interference when I'm told, sorry, she can't come and live here? That was the situation in Keeler.
And for family life, and we've been focusing on private life.
Family life.
That's the point. Or part of the point.
There is a difference between family life and private life.
But so I think the two different issues are being elided here. Whether we're talking about family life or private life, it's not going to make any difference whether I'm talking about a positive or negative obligation. It's my submission. Because the ultimate question is always whether a fair balance has to be struck. So can I just give you?
So you assume there's an interference, and then you talk about proportionality. That's your submission.
So
you can't ever engage with the question of whether there is an interference in the first place. You jump straight to question 2, which is whether it's proportionate.
So, my lady, I'm not sure why we're talking about a private life.
Because one half of the decision
is about private life.
The sponsor's private life was interfered with.
So
that was paragraph 96, I think. There are 2 reasons why your client won. One was that there was an interference with your client's daughter's family life, and the second was there was an interference with your client's daughter's private life. So she had mental health problems, and the stress, understandably, the stress of being here in London, seeing the news and wondering what's happening to your mother, causing her to deteriorate.
So sorry, maybe I can make it clear. We're not suggesting for a minute that if there was no family life between the sponsor in the UK and the appellant, that private life would be engaged. I'm going to come. I'm not suggesting that. There's a different.
98. It would tell me just to clear out what is and isn't an issue.
So
98 said, does the refusal of entry clearance to a mother interfere in the sponsor's private life? And he said so the reasons why, but you're not relying on that, are you?
So, my lord, I'm not yet there. I'm in a section of the judgment which deals with the question whether with the approach to family life. And in that context,
going back to paragraph 16, and the question was there a distinction between positive and negative? And I raised the question of private life because I knew that she said paragraph 16 in the context of paragraph 98 comes later. But I'll let you get there in your own time then.
Thank you. Yes. So just at this level of abstraction, there is no, in a family life case, which is what this case is, it's a case where the application is made by an appellant who wants to come to the UK to, and who argues that it would be a breach of her family life rights, then there is no principal difference between positive and negative obligations. Can I just, I think these are referred to in the skeleton argument. The authorities are Keeler, which is in the bundle, and Hesham Ali. Keeler is referred to in IA and others without any disapproval.
So paragraph 16 is wrong in sentence 1. It's not, or sorry, in sentence 2.
It's correct, entirely correct. It's consistent with,
Right on negative positive obligation.
it's correct on whether the ultimate question being where a fire balance is struck. Again, that's what's said in Hesham Ali, and it's said in Keeler. Hesham Ali in country, Keeler out of country. And then there's likely to be a combination of elements, and financial support on itself is not sufficient to constitute additional ties of dependency. That's correct. It's important not to be over prescriptive, and comparisons with outcomes in different cases unlikely to give any material assistance. Correct, we say. Moving then through, so then we have the history, moving then towards the decision. All the findings of fact not disputed, jurisdiction has been decided previously. Jurisdictional PEG 95 is provided by the sponsor in the UK. My Lady's judgment in Ali was not of relevance because the appellant never suggested that she should be allowed into the UK to pursue a private life in the UK. And that was the basis upon which it was common ground that if the appellant succeeded, the questions which took this case within Article 8.1 related to her family life, not to her private life. And just to foreshadow what I'm going to say about private life, what we say is that once you've got there, then you have to look at all relevant factors. It's what the Court of Appeal did in IA and others, and that will include the impact on the sponsor.
So if we don't get to family life, if we win on family life, then that's fine.
Yeah.
But if we don't get to family life, are you saying then the private life of the sponsor is not relevant for the ultimate analysis?
I'm just going to say, I'm just going to check that I understand my instructions, but yes, we never said. Yeah, so we've never sought to argue. I'm not, it's never been part of our case.
I'm not really interested in the history of the archaeology. I want to know what your case is now. If you don't get to Article 8 family life, if you do, you're fine. If you don't get to Article 8 family life, then you wouldn't be relying separately alone on paragraph 19.
My Lord, I am not making a submission that the private life rights of someone who did not make the application and who is not an appellant could by themselves create the jurisdiction of the tribunal. So I'm not saying that anyone has a right to apply to the United Kingdom, say, I want to come to the United Kingdom because of the private life rights of someone else, and that when I'm refused, that would create the tribunal's jurisdiction. We've never made that. That's never been the way in which this case has been put, and I would not like to be seen to have taken a view on that either way. It's simply not the way this case has been put.
If you lose on family life, do we need to trouble about 98, paragraph 98? If you lose on family life.
My Lord, no. So if we, yes, we've never, if we don't, if you find that that this appellant does not have a jurisdictional PEG because she doesn't have a family life tie with someone in the UK, then the tribunal couldn't consider this appeal. Just in the same way as my lady revisited what had been, as you explained, a misreading really of Abbas in the context of a different case. I wouldn't want to say never, because I can't think at the moment. I can't think of a moment. But we have never dealt.
with one case, which
Yes.
is this case, And I'm only dealing with paragraph 98, and I'm now written down, if you lose on family life, we're not relying on Article 8, paragraph 98 of the sponsor's question.
We say that paragraph 98 identifies matters which are relevant, they were properly relevant to the decision of the Upper Tribunal, and it would have erred in law if it hadn't taken them into account, but that they couldn't have established the appeal. So yes. Thank you.
Oh, that's very helpful, thank you.
So my learned friend takes me to, sorry, it's my skeleton now. Yes. Yeah, so it's certainly correct. 234, my learned friend has taken me to 234 to 235, and that's absolutely right. We did raise the question whether, and we asked the tribunal.
I'm not asking about what you did
Yes.
before. You've answered the question twice, and I made a note of it. I was really only asking about this afternoon, what you're relying on this afternoon, and you told me. So please don't worry and use the time on what might have happened in other.
My lord, sorry, I'm just in fairness to my learned friend, he's asked me to look at a document. So it's absolutely right that we raised this issue, but we raised it consistently. So it's with the way in which I'm going to put it today, which is that once you are in to an appeal, then all of the through family life, then all of the interferences which are occasioned by the decision have to be weighed together. I'll come back to it. So back in the paragraph which we accept includes an error, paragraph 16. We point out that even in that paragraph, it's clear that the tribunal had in mind the need to establish additional elements, additional ties of dependency. It's 5 lines down in paragraph 16. And then the section where the tribunal made its decision about whether there was protected family life, page 128, starting at paragraph 99. Assessment is entirely fact-sensitive. Take into account the history and relationship between the appellant and the sponsor. Then 100, the history. 30 years of emotional and financial dependency. Main financial provider throughout adult life. So we've got financial dependency throughout adult life. Sole reliance on the appellant financially. We accept that doesn't establish dependency by itself, but it's one of the factors which weigh together with emotional dependency, we say clearly take us over. Paragraph 104, we place significant weight, so within that context, on the long-standing history of mutual emotional support between the sponsor and the appellant. And then some of the elements of that. And then the finding, the appellant is, and it's not a challenge finding, it's also particularly dependent on the sponsor emotionally and financially at the current time, and some of the additional reasons for that. And then the separation is causing the sponsor distress and impacting on her ability to carry on with her normal life. And we say that in circumstances where the tribunal has made an express finding of particular defendants emotionally and financially, it is in substance making a finding of dependency over and above the normal emotional ties between family members. And that's a finding of fact. Oh, it's a finding of it's an evaluative finding based on the findings of fact. not challenged. The tribunal also finds 107 that the relationship exceeds the normal emotional ties between adult family members. So that's the other half limb of the correct test, as identified by the Court of Appeal in IA and others.
Doesn't it go wrong again when it starts saying, and that there is effectively a, you say that's all right because you can refer to it as a factor.
It's not wrong in itself.
It's all right as a factor, yeah.
So the question is, does the fact that there are findings? So I'm exactly going on to say there's also a finding of real effective, real and committed support, both in terms of financial and emotional support, and there is the existence of close personal ties. These are all different ways in which the test has been put, but they all have to be read in the context of the finding of particular dependency. And we say that stepping back from it, if you ask this tribunal, the tribunal has made findings of fact, no one is suggesting it acted with any kind of impropriety. If you step back and ask this tribunal, okay, the test's actually additional elements of dependency over and above normal emotional ties, it would have not had to make any further findings of fact in order to answer that question, yes. You have all of the elements of it. It's absolutely clear that what the tribunal is saying is that this is a mother and daughter who have the normal emotional ties, and they have particular levels of emotional and financial dependency, mutual. The appellant has those, and the separation is causing responsive distress, impacting on her ability to carry on with her normal life. Not just upsetting her, not making her sad that she hasn't got a pen friend here, it's causing her mental illness. And in the context of that, the tribunal at 105 and 106 deals specifically with the Secretary of State's main points. They haven't seen each other very often, they've lived separately. There are other family members in Gaza. It's dealt with all of those. Can't be suggested that it's failed to have regard to anything relevant. So our overriding submission is just that if you look at that set of findings and you ask, notwithstanding the understandable error error in the statement of the ultimate test in paragraph 16, do we know from those findings what the tribunal's answer to the question was, the amended test? Because if we do, and I submit we do, then the error in paragraph 16 is immaterial to the outcome of this case. And my lady, my lords, just to deal with disposal already at this point, if you're against me on this, I would say that this is a case which should be remitted. The IA and others case was a case where there was a positive finding that there was no dependency. This is a case where there is not a finding of no dependency, there is a finding, unchallenged finding, of particular emotional and financial dependency over and above close personal ties. A long history of this. It would not be right, I would submit, for the court, which has to determine the position as if the court steps into remaking, it has to just determine the position as of now. It would not be right for the court to determine that without giving the witnesses the opportunity to address the correct test.
What are the facts relevant to this family relationship?
Well, 15 months have gone by since.
15 months have gone by, and she hasn't been in the United Kingdom, she has been in Gaza. So,
my lord,
the report and the levels of involvement.
So you would hear evidence about the sponsor's mental health, you'd hear evidence about the sponsor's...
We don't get there if we don't get to the family ties. I thought we'd gone through that. So
No.
we get the family ties first.
My lord, no, I'm sorry, that's not right. The sponsor's mental health is relevant to establishing whether there are elements of dependency. If we have a pair of people who are mutually dependent on each other, then the evidence of the impact of separation on both of them is relevant to the prior question of whether there are family ties. And you'd have evidence about the appellant's circumstances, the way in which the appellant has received support from the sponsor in the last 15 months. It would be unsafe, I would respectfully submit, for you to determine this case in circumstances where the tribunal applied, you would have found that the tribunal had applied substantively the wrong test, but it had found elements of dependency, and without giving the appellants the opportunity to address, the appellant and the sponsor the opportunity to address that correct test by reference to the up-to-date evidence, and in circumstances where it may well be that the tribunal, we simply don't know. If you're not with me on my main point on ground 4, and you think that there was the error in paragraph 16 was material, then we don't know what the tribunal would have done. And my lady, my lords, you don't know what the evidence would be if this matter was being determined by the tribunal now. You don't know what the sponsor, what a tribunal would make of any updating evidence from the sponsor or the panel. It's very different from the situation in IA where there was never any prospect of any new evidence being put in, any relevant change in circumstances. There was no longer any prospect of a decision about entry clearance. So I'd invite you not to reach your own decision on fluid and changeable facts in circumstances when you haven't had the opportunity to hear from the sponsor. And
Apart
then,
from the mental health of the mother and the daughter, are there any other facts that we ought to be aware of might have changed?
so the level of communication, the steps that are taken to assist the steps that are being taken. It's very difficult for me to do this without me starting to give evidence. And I shouldn't be having to do this.
That's why I phrased
So
the question in the way that they
yes.
did. You said the mental health,
me-
and anyone who, not even a doctor, can see that mental health will change from day to day and month to month. I understand your
Yes.
So I phrased it, are there any other facts that we might be need to be very careful of thinking those things could have changed?
Yes,
You
so
said
the nature of
communication.
the nature of the emotional and the financial and practical support which the sponsor is giving to the appellant, and the extent to which she's dependent on that support, and the circumstances in relation to other family members and where they are and what's happened to them. And all of those are matters which would be addressed in updating witness evidence and which the sponsor or someone could be cross-examined on. I've got quite a lot of ground still to cover, and I really I appreciate we've had a long day. So I'm going to give you, rather than taking you through those 3 decisions, may I just give you what I submitted, the ratios of the 3 decisions, and then we'll see whether I need to address you further. So a BAS, and we take the ratio of the BAS from my lady's judgment in Ali. A BAS does not, Article 8 does not oblige a state to allow a non-national to enter its territory in order to develop a private life there. And the explanation that in that context, develop means start from scratch, create a private life which doesn't exist. And that was, of course, the floodgates, that was the floodgates scenario which had concerned, well, Justice Burnett in Ali. Anyone could say, I want to have a private life in the UK, and you're denying me that option. Kopoi, and that's just context, it's a young woman, an adult young woman, who wants to visit the UK for 3 weeks in order to build up family life ties with a child who she'd met once when he was 2, and a child she'd never met before.
Were they family members?
They were the son and daughter, I believe, of her cousin, of her first cousin. Yes, so the son and daughter of her first cousin. They were second cousins, that's right, yes. 3-week visit, no health concerns, nothing else. There was an interest in the children in the UK getting to know their family outside the UK. And we say that the ratio in Kopoi is that Article 8 does not oblige a state to allow a non-national to enter its territory for a short visit in order to develop, again using the word in the way that my lady used it in Ali, in order to develop a previously non-existent family life. So what happened in that case was that it's one of these cases which all these cases came about very shortly after the change in the jurisdiction. And the tribunal was clearly uncomfortable with not being able to allow visit visa cases. That was and it was wrong about that. But in this case, the tribunal, the First-Tier Tribunal and the Upper Tribunal had given no adequate reasons for finding there was any family life at all. Lord Justice Sales and Copoy said there is no basis upon which family life could be found. As a matter of fact, by having regard to the facts, that's not the ratio. The ratio is that in circumstances where there is not family life now, Article 8 doesn't oblige a woman to come to the UK in the hope of establishing one. And Onaruja is a case where Kugathas had been applied, and Kugathas had been applied in a way that doesn't really matter whether it had been applied in a way that was more favourable or less favourable to the appellant, because the tribunal had concluded that on any view, Ms. Onaruja, she was trying to visit her brother in the UK. She was an adult visiting her brother in the UK, and on any view, the Kugathas test was not met. But the Upper Tribunal concluded that in visit visas, a lower threshold of test should be applied for the engagement of Article 8. And Lord Justice Singh said no. So the ratio of Onaruja is that the test for family life, in other words, the additional elements of dependency, is not relaxed in visit visa cases. That's all that claim that case establishes, and none of the.
It doesn't preclude you. I can see that there might be cases on your analysis where a family member visiting might come in. You can't say these three cases show that they can never come in. But in a situation where, on this hypothesis, what the Upper Tribunal found, that the mother was intending to come not to stay and develop a relationship with her child, although that would be part of it, but to have a particular set of medical procedures at the hospital, and she wanted to return to children in Gaza. Is that a relevant factor in assessing whether there's additional ties of dependency or whatever the phrase is? Is it a factor that's relevant? The duration and the purpose of the visit? So
Lord Justice Singh in Onaruja held that the nature of the visit was logically, sorry, my lady, my lords, can I just move forward and get a glass of water? I've run out of water in front of me. There's one just here.
So on the fact of this case, I'm thinking about this case,
yes.
Really, and I'm not really interested at the moment in the other cases unless they help answer this question.
Well,
and the question I'm asking to myself is the fact, A, that the purpose of the visit was actually for medical reasons, although I see that there would be other things happening at the same time, and B, is it intended to be for a short duration, 6 months, possibly up to a year if the operations take longer, is either the purpose or the duration of the visit relevant to the assessment of whether or not there's the additional ties of dependency or whatever the phrase is.
So more no.
They're not
I say
relevant.
no. They're relevant to the question, and we say that's the approach that Lord Justice Singh took in Onaruja. I can't rely on. They're not. They will be relevant to the severity of the interference potentially, and they will be relevant to justification, but they're not relevant to the question whether I have family life. They may well cast light on the question whether I have family life. That's a different point. They may well cast light on. So the reasons for a visit, the fact that the reasons for the visit, if believed, and the evidence about what is intended to be done on the visit, may well be relevant to the question whether there are actually additional elements of dependency. So if a tribunal believes me when I say I need to be with my daughter while I'm going through a difficult operation, I need to have that time because it's the only person that I feel close enough to be able to get me through medical appointments. And if that's believed, then in those circumstances, the purpose and the length of the visit could be relevant.
That sounds like a submission. They're relevant if they help you, but they're not if they don't.
No, because if the tribunal said no, I'm terribly sorry. I think all you want is a better doctor. I don't believe you. Then I accept that might be relevant as well. That would
You
be
say
part
it's an important part of the factual background.
Yes. So it's no less important than the fact that. So we would say in the same way as we would rely on the fact that when the appellant last needed medical treatment, the daughter, her sponsor, went and spent 3 months with her, and took time off work or took time away from a desk and went and spent 3 months with her in Jordan. In the same way, the fact that they've decided this is how the sponsors, the appellant's medical treatment should be best be managed is relevant. My lord, I'm not suggesting it's only relevant if it helps us.
Down. Tell me if it's wrong, because it's important that I'm corrected, because I might have misunderstood. I'd written down the purpose and duration of the visit was not relevant to whether a family relationship existed. It could be relevant to the seriousness of the interference.
No, so I'm saying more than that. I'm saying that the difference in itself between a short stay and a long stay isn't relevant. But I am saying that the nature. So you look at all relevant factors in deciding on the strength of the relationship. And what was said in both of those cases, on Aruja and Kopoy, is that if you haven't got a relationship, so what Lord Justice Sales said in Kopoy, it's not going to get much stronger on a 3-week visit. So a submission was being made that the family should have the opportunity to build up those previously non-existent ties. But it's not, and similarly on Aruja. So what you can't do is say, at some point in the future, if I have some visits to the UK, I will have a family life. That's what's rejected in Aruja. That I can't say, by the end of this visit, I'll have family life, and therefore I have family life now. Well, sorry, maybe I'm not making sense. I can't rely on the state of my family life at some point in the future after a visit in order to show that I have family life now. But if I give evidence about why I'm coming here, why we want to see each other, why that's important to me, that may be relevant evidence, because it's evidence about the nature of my present relationship.
But the point either way, my point, I want to see my daughter. I haven't seen her for 20 years. It'd be nice to see her if she's going. Yeah. That would show there's not a family life, it's family capture.
Exactly.
So it is a fact potentially relevant for or against, depending.
But it's relevant to the assessment of my family life now. So I can look at what my intentions are. The reasons why I want to come to the UK may be relevant to judging whether I have family life now. If I'm believed, if I give evidence, I can't imagine having this operation without having my daughter here, because she's the only person I can talk about.
The facts are, well, I want to have an operation, and I want to come to London to have the operation, and of course it'd be convenient because my daughter lives there, and she'll be able to help me with everything. That might sound as if it's not evidence of additional time of dependency, say for the period that she's in London.
So I can't imagine anyone else looking after me when I'm in the state I'm going to be doing this operation. She's the only person that I feel close enough to in the world to look after me. That would be relevant. If someone said that kind of thing and it was believed. I'm answering this at a level of a slightly hypothetical level, and I have so much to go. I'm already going to be asking for an extension of my submissions to 15:15 if I may, because this is.
Sorry,
I'm just trying to.
We probably seem to be interrupting you an awful lot, but we really do have to finish at 4:15.
So I'm going to. May I move on, because I've got a number of grounds to go through still. Though I think that these possibly are the ones where I have the most to say. So I hope I've explained it. The focus has to be on whether I have family life now, not whether I have some prospective family life that will come into existence in the future. But when answering that question, my intentions and the reasons for my visit may well be relevant. I don't put any higher than that. Ground 5. So I just check that there wasn't anything else on ground 4 that I wanted to address you on. Yes, sorry, the only other point I want to say is that it did seem from my submissions, at least the written submissions, that there was a factual precedent created by IA which was fatal to this claim. That can't be correct, both as a matter of principle and as a matter of fact. The claims are so very different. The fact that they relate to people in Gaza is not enough. Ground 5, you already have my submission about the reasons why private life is relevant. The Secretary of the Entry Clearance Officer argues that the approach of the tribunal was inconsistent with the territorial scheme, inconsistent with the decision in Abbas, and inconsistent with the decision in IA. And just quickly, we say none of those submissions are made out. It's not inconsistent with the territorial scheme because the sponsor is a British citizen living in the UK. Her rights to respect for her private life, she plainly has a right to respect for her private life in the UK.
The private life doesn't matter, it's a family life that matters.
No, but so Malone Friend is objecting to the fact there's any reference made to her private life at all.
We've got this.
Yeah.
If she can't get home on private life and family life,
no,
that's
she
the
can't
end.
get home
If
on
she
family
can get
life.
home on family life, then you put the private life impact into the balance as
It goes
well.
into the balance.
You said that.
Yes. Nor is the Upper Tribunal's approach inconsistent with Abbas for the same reason. Abbas is about the private lives of people outside the UK,
Yes.
and nor is it inconsistent with IA. And can I maybe just ask you to look at paragraph 172 of IA? You don't need to turn it up, but in IA, once you get to the proportionality exercise, the impact on the mental health of the sponsor was a relevant consideration.
You said earlier on today, yeah.
Yes, I'm just making the point that that nothing in IA is contrary to that. So those are my submissions on ground 5. In general terms, because I'm going to whistle through this, can I ask you, I of course rely on our skeleton argument entirely, and quite a lot of what we say about ground 6 to 8 is set out there. I would, before I get to it, and because I'm likely to have very little time on it at all, I would agree, I think, with a point that was put by my Lord Justice Lewis to Malone Friend, that if the Secretary of State doesn't succeed on his ground 6 and 7, then ground 8 adds nothing to it. But I will
You really made your submissions on 6 to 8 with your submission that you've got to look at all the facts that are relevant to whether there's been a breach of Article 8.
Yes, well, that's our overarching point. Can I just, in the last sort of 12 minutes or so, just develop some aspect of that, and also address on the particular point about the possibility of return to Gaza. So on ground 6 to 8. I'm sorry if you'll bear with me. I'm just trying to jump through, and it'll save time. So, the background to the rule. There's a mistake in the skeleton argument, and it's my fault. That you can apply for up to 11 months first time round, but in fact you can apply for extensions of time as often as you continue to meet the requirements of the rules. So a person could continue to apply for extensions of time beyond the first year. It's not relevant. It's not what the appellant wants, but it's just a mistake in the
So you
skeleton.
can have, so it's not just as I thought, 6 months and then up to 1 year. This could go on from year to year.
No, as long as you continue to meet the requirement of the rules, you continue to have the finances, you continue to meet, and that just reflects the fact quite properly that medical circumstances can change, provided you continue to be a private medical visitor. Thanks. So that's me misreading the rules. Can I take you to paragraph tab 24, page 487? And this is the policy that you've already been taken to, and we say that this is an indication of what the Secretary of State thinks that the visit visa rules are about, and we say quite rightly.
Am I in the authorities bundle?
My Lord, sorry, yes, you're in the authorities bundle, tab 24, page 487.
This is a bit that we haven't looked at yet.
It is, yes, but it's relevant to the public interest point. So 3 lines. So it's the final paragraph on page 487.
Yeah.
It would generally be proportionate to refuse entry clearance if the applicant did not meet the requirements of the rules. That means the visit visa rules, even if that did mean that the UK was not complying with the positive duty. Well, dispute what that means, but the point is there, the Secretary of State recognising that a decision about proportionality is going to require someone to decide whether an applicant meets the requirements of the rules. And then
It says that in the penultimate the paragraph that you just skipped over, you've gone straight to the bottom one, but yeah, it says in terms the applicant's ability to meet the requirements of the immigration rules is relevant to proportionality. You don't need much more than that, do you?
Well, no, sorry, I'm trying to get to the core paragraphs. I've missed out on the best one. But then the next, so I'm grateful. And then the next sentence: maintaining effective immigration controls in the public interest. That is section 117B1, almost in terms, or probably in terms. The immigration rules set out the requirements that must be met by visitors. So 117B1 is informed by the immigration rules. That's the point of the immigration rules, is that they provide for orderly, consistent exercise of immigration enforcement powers. And we'd say it's an obvious comment that it's maintaining effective immigration control, not enforcing willy-nilly, which is in the public interest. Those requirements are established, so these are the requirements of the immigration rules, no distinction between Article 8 and other ones, in order to ensure that decisions made to grant visit visas are in the public interest. To grant, it's in the public interest that we have an operative, functioning visit visa system in which people come to the UK and spend money in the UK and so on. For example, the person must be a genuine visitor, can be maintained accommodated without accessing public funds, doesn't intend to breach the conditions of their leave, and there are no suitability grounds for refusal. Where those requirements are not met, it's not generally in the public interest of the individual to enter the UK. So whether it's on the Secretary of State's policy, whether it's in the public interest for a visitor to enter the UK is going to depend on whether they meet the requirements of the rules. And it's in those circumstances that we say whether you meet the requirements of the rules is a relevant consideration in determining an Article 8 claim, and that by Section 85 of the 2002 Act, it's therefore a matter on which the tribunal has a discretion to make findings of fact, and we say it would exercise the discretion normally in order to make those findings.
It doesn't go quite as far as you would like, of course. It says that if you don't meet the requirements of the rules, it's not generally in the public interest to let them in. It says it's relevant to ask whether they do, but it doesn't go quite so far as to say that it will almost inevitably be the case that if they do meet the requirements of the rules, then you should let them in.
So there are two answers. Malay, just going back onto page 487, I'd submit that is pretty close to, if not exactly, if not quite there, to what's being said 5 lines down in that paragraph. Those requirements are established in order to ensure that visit decisions are in the public interest. And that's why I said that. But also, ultimately, you don't get a bonus point. When we get to the fair balance exercise, I don't get a bonus point for being within the requirements of the rules. My meeting the requirements or not meeting the requirements of the rules goes to the legitimate aim. What is the legitimate aim? Or what is the public interest in excluding me if I fall within the rules? So actually, it's the negative which is the most relevant here. I don't get additional weight on my side of the balance.
The intellectual framework for this is if we are trying to decide whether or not the tribunal takes a fact-finding role for things that might be relevant to proportionality, such as whether somebody is going to leave or not leave at the end of a medical visit, is your submission that this shows that at least the Secretary of State, when she gave guidance, thought they could, and we should be influenced by that when we decide.
Well, we say that it's how the Secretary of State understands the function of the rules. I'm not sure whether I'm saying you should be influenced by. I'm saying it's right. The Secretary of State, I agree. We agree with.
It's right. I need to know why it's right. I'm trying to work out the intellectual framework. Are you trying to say, look at this? This is something that tells me whether these are or not matters for the tribunal, or the Secretary of State understands things all the time. She's constantly being told by these courts she's got it wrong. So I mean, I'm trying to work out the relevance.
So we're saying that I'm effectively adopting this. I'm saying these are the purpose of the rules is to show who it's in the public interest to let in and who it's in the public interest to get out. Whether you meet the requirements of the rules is therefore relevant to the proportionality exercise, both because if you're within the rules, there's no public interest in removing your, refusing your, and if you're outside it, then there is. The starting point is that the public interest in immigration control acts in favour of a refusal. The consequence of that is I do have to show something exceptional. I do have to show something additional if I fall outside the rules. My submission is then that in those circumstances, the question whether I fall within the rules or not, and if not, why not, are relevant factors for the tribunal to consider, and in exercise of her powers under sections 82, 84, and particularly 85 of the 2002 Act, she's plainly permitted to, and may often be required to make findings about that. If the Secretary of State says, I want to refuse you entry clearance because you're outside the immigration rules, and there's nothing exceptional about your case, then it's necessary for the tribunal to decide whether the Secretary of State is right as a matter of fact. And we don't need to go into...
In a human rights case.
In a human rights case, of course, not in any other... In any other case, the tribunal doesn't have jurisdiction to even start. But if once you're within that human rights context, where meeting the requirements of the rules is going to be relevant to where the public interest lies, then the tribunal can't just avoid that. And the tribunal has to make those findings, as it has to make findings about anything else. Well, so that's the way I'd ask. I suppose I'm saying we agree with that paragraph.
I think you're saying it comes from the Act is once the Secretary of State got it right. That's what
It may be that's what we're saying, but it's yes.
But you have to get it right sometimes,
Statistically, yeah, she's bound to.
even if the rest of the policy doesn't make any sense.
That's the logical framework for considering the relevance of this piece.
Yes. Yeah, I'm going to. You already have our submissions on TZ. You were taken there. I don't think I better do that. But there is, in the case of TZ, we rely on paragraph 34. I don't need to take you to it. It's in the skeleton argument. I'm sorry, I don't have the page reference. But it's on paragraph. It's tab 17, paragraph 34, and what's held there is that. So that the approach is that where a person satisfies, so the approach which is recommended is that the finding is made as to compliance with the rules before a finding is made as to whether someone should succeed outside the rules. And this approach, paragraph 34 says this court has the benefit that where a person satisfies the rules, and we emphasise whether or not by reference to an Article 8 informed requirement within the rules. So in other words, the same approach applies whether the rules are expressly Article 8 rules or not. The benefit of asking yourself whether a person meets the rules is that if they do, this will be positively determinative of that person's Article 8 appeal, provided their case engages Article 8.1, for the very reason it would then be disproportionate for that person to be removed. So just breaking that down, provided the case engages Article 8.1, if we're not within Article 8.1, the tribunal has no business deciding whether the immigration rules apply. That it has no jurisdiction to do so. But once you're into Article 8.1,
And it's got no choice, really, you say.
well,
Because it's relevant.
It's relevant, and it's not only relevant, but if the tribunal disagrees with the Secretary on its own findings, having seen the witnesses and all the things that get identified in plan, if it decides that in fact the requirements of the rules are met, that's positively determinative.
You would say it's actually you're in a very different scenario there, because once you're into Article 8, then ultimately any sort of human rights infringement ultimately is a matter for the tribunal or the courts to decide, and not for the Secretary of State to decide. And so once you're into that whole ballpark, then everything factors into the answer. That's really the basic point that you make.
Absolutely, Malay. And so the question, what happens if you've got a rather unusual criterion, which is that it should not be conducive to the public good and so on. Yeah. That's dealt. I'm not sure whether I need to deal with this actually in this argument. You can imagine cases where, or kinds of factor where
it might fall into the suitability requirements, but we don't have to go down.
Yes, we don't have to go there, Malay. So where what is needed.
Say, for example, the Secretary of State said it was not conducive to allow somebody to be in the United Kingdom because they were a right-wing extremist and they were encouraging populism in a way that the government thought irrelevant to take highly unlikely circumstances.
Yeah, they're not that unrepresentative. It's arisen in SIAC.
And the tribunal then say, well, no, we disagree with you. We actually think it's better. It is conducive to the public good thing. We think there should be free speech across the board, and we should hear what this man or woman has to say. Are you saying that the tribunal has to decide that?
I'm saying that I'm not making any submissions.
There's an 8-2 justification.
It doesn't arise, and I prefer not to make submissions about that. My lady and my lords.
No. It doesn't arise, so don't waste time in it. Then that's absolutely fair.
There's lots of guidance about areas of institutional competence and so on.
Once you're into areas of policy, it all becomes a bit hard. But you say don't need that for this case.
We know what the policy is. The policy is if you're going to go back, exactly. So can I go on then to ground 7? This is the misstatement of the rules. Now you have most of my submissions on that in my skeleton argument. The only thing I'd like to address you further on is this question about going back to Gaza. Can I just say, you asked whether there was evidence about ability to go back to Gaza before the tribunal. I think I do need to say this. My learned friend raised the point about practical ability to go back to Gaza for the first time during the course of the hearing in the Upper Tribunal. So you won't find evidence about that in the. It's not part of his skeleton argument even before the Upper Tribunal. We all have ideas that come to us at later stages, but that was a point that had never been part of the Secretary of State's case. And as you've seen, and I don't need to take you back to the decisions, the Secretary of State approached this in her own decision making, approached this decision on the basis that if I need to know whether someone will go back, I ask whether they genuinely intend to, and that's what commonly that was that.
Where did you get that from?
Well, we can get sorry, I'm probably shortcutting. We see it from the decision itself, where although you see that the basis upon which
it's all the references to intention that you took us to this morning.
Exactly, and then you were taken to the policy, which also relates to intention. So the way in which the Secretary of State presented her case before the tribunals until the very end was that it was not believed that the appellant would in fact intend to go back to Gaza.
But doesn't the means of getting there feed into the question of intention?
Well, it feeds into. I'm not sure what it does, but it does feed. It does potentially feed into a question about whether someone will go back. But the point there is that there was what we say. Our short submission is the Upper Tribunal was absolutely entitled to conclude that it was being asked to speculate. The Rafah border has opened and closed at various points since it was open. For instance, when this application was made, it was open when the pre-action letters were sent. It was then closed for a while. It was reopened. It's open now. Thousands of people have gone back into Gaza already, and we say that the Upper Tribunal was quite right to say, when presented with a new submission on the day of a hearing, unsupported by any evidence, that it was being asked to speculate about a possible geographical, historical, political situation sometime several months into the future, on probably more than several months, given how long it would take for FA to get here. So our first point, over and above the points that I've made in the skeleton argument, is that the tribunal, reinforcing a point, that the tribunal was absolutely right to decline to engage in speculation on that point. And the second point I do make is that, and you have in the agreed supplementary bundle the submissions made by the requests for disclosure made by my instructing solicitors to GLD, and which identify a series of statements. So it's in the supplementary bundle, and it's at 355. It's the last item, 355 to 362.
Yeah.
Mr. Malik, cross-examine the sponsor on this. Did he ask questions about how's your mother going to get home?
I think yes. I think that was how we realised that there was.
So he did raise it.
Oh, he raised it in the hearing. Yes.
And she gave evidence about it. Did she answer the questions?
I don't remember what her answer was to the question. I think her answer was probably we'll work it out when we get there. I can try and find out a record of the proceedings. I'm not sure whether my learned friend has a record.
Were asked about the ability of the mother to return to Gaza.
I'm not going to go to
this letter. Is this the last letter in the bundle?
It's the last letter in the bundle, and
Yes.
what this does is it expands upon. So at the time of the skeleton argument, we'd become aware of the witness statements that had been adduced in one of the challenges. There's an FCDO challenge. So it's a challenge to refusal to assist people in exiting. And so really the evidence is referred to at page 358 onwards of the bundle. And as I say, there was no objection to this letter going into the bundle. It's been put in by the Secretary of State
What point does this go to?
So it goes to, for instance, on page 359, Tom Purseglove in May 2024. There are provisions that allow a person to come to the UK for private medical treatment under Appendix V of immigration rules. And then if the rules are not made, careful consideration will be given on whether a grant of leave outside the rules were appropriate. The point we make is that the Secretary of State, as a matter of statement, obviously considers that it may be appropriate, that the medical visit visa is available. Now, if her position was that set out in Mullen and Friends submission, then no visit visa application should ever be granted to someone from Gaza. In other words, the Secretary of State is recognising there, implied that people will be able to go back eventually.
Well, you've got to be a bit careful about this because visit visa applications can be made outside the context of a human rights claim. And we don't know whether this policy statement was referring to general Article 5 applications or ones like this, because the norm would be that an application would be made under Appendix 5, and if it was turned down, there would be a JR.
Yes.
So I'm not sure you can get anything from a statement that some MP makes at certain stages about the availability of this route. Well, we all know the route is available or potentially available, but the question is it available as a human rights claim? And that's what this case is all about.
No, Melody, all we're saying here is that there appears to be evidence. I don't want to put too much weight on this. It's a very much a fallback position, because our primary position is that the Upper Tribunal was right not to think that it was being asked to speculate about circumstances in the future. All we're saying here is that, for instance, on
I'm
page...
more worried about whether we should even look at parliamentary statements, because we have to interrogate it. The last paragraph of that parliamentary statement is going on about Palestinian children.
Yes.
And you're thinking maybe, I mean, if you've seen a hospital bombed and all the parents have been killed, you've got poor children burned terribly, you'd have to have a heart of stone not to want to try and do something
Yes.
to bring them out, whatever the law says.
Yes.
And it isn't usually right to question and interrogate statements in Parliament in a court case. Indeed, Article 9 of the Bill of Rights of the law says
So
we
you
shouldn't.
shan't.
Well, we're not. So of course we're saying that we're not seeking to. Can I then refer you to not those passages? What you will see that the reason why this was written is because it was a request for disclosure. But can I just refer you to an extract which, under no circumstances, is impugning Parliament. It's not a parliamentary statement. It's a statement made in open court by an FCDO witness, page 360, where one of the three pillars of the FCDO's policy relating to Gaza, its 11B, is ensuring that the UK is assisting with visa applications for those eligible to apply for private medical care under existing immigration rules. It's the FCDO thinking this is open to people from Gaza.
So I can't find the sentence you're reading from.
My lord, sorry, it's halfway down page 360. It's highlighted in.
With the highlighted
And you see again, it's in the same. Sorry, in a different witness statement. This is a Home Office witness statement, also from the same proceedings, on page 261, where the Secretary of State, the witness on behalf of the Secretary of State says that students and medevac cohorts. This medevac's not the same as what as FA, but they're coming to the UK for a limited period before returning home. Simply saying that the government's position, as set out in witness statements before court, appears to be that the government contemplates people returning home to Gaza, and we say we don't need more than that to show that the submission that was advanced by my learned friend with respect was perhaps not properly advanced, and would have been advanced had there been reflection on what other government agencies were sayaying. I don't want to put it any higher than that.
It says there were a brief period between January and March 2025 when Egypt allowed crossings through Rafah for medical evacuations, although HMG weren't involved with it. It's very difficult to see what we can get out that's going to assist this case.
Well, you can get out of that it would be difficult to speculate on when the border next opens, which is all the Upper Tribunal was saying. The Upper Tribunal is saying, don't ask us to speculate. You put in no evidence whatsoever, Secretary of State, in support of a point you take for the first time in the middle of oral hearing, and you're asking us to speculate about and in fact, the speculation would have been wrong because it has been possible to get back through the border, through Rafah since the beginning of this year. We're not seeking to say anything more than this is further evidence that it wasn't open to the Secretary of State to come into court and make an assertion made without reference to evidence that it was impossible to go back to Gaza. I don't think I have anything to add to that. Again, our primary submission is that the Upper Tribunal was being invited to speculate on the basis of no evidence and was right to decline to do so. Ground 8, I've addressed you on that. It doesn't add anything to grounds 6 and 7 if they're made out. But beyond that, I rely on everything that's said about ground 8 in my skeleton argument. May I just look behind me and check I'm aware of what's happening? Sorry, yes, I've just been asked to say that the sponsor and her husband are on the live link. I'm not sure whether the court's aware of that. They're on the live link. They'd wanted to be here, but because of the heat, it's not been possible to travel. So, but that's why they're not physically here.
Lords, five very short points. The first point concerns ground 1. Friend says that in the decision letter, Secretary of State is conducting RASGA 1 assessment, and that means that there is a refusal of a human rights claim. Now, in deciding whether to accept or reject that submission, I do respectfully invite Milady and Milords to consider the implications of accepting the submission. The implication is that the Secretary of State, whenever a person sends a letter to the Secretary of State that I have an Article 8 claim, and the Secretary of State says that I don't accept that you have an Article 8 claim because Article 8 is not engaged, is not capable of being engaged, the Secretary of State would be refusing a human rights claim.
Well, he could write back and say, I decline to take a decision on this application because I do not see that the question arises for decision.
Now, and that, my Lord, with respect, would be immediately amendable to judicial review. The applicant,
Exactly.
the applicant would say, well, I have said something.
I've made a claim, you've got to determine it, you can't sit on the fence. That's what they would say.
That's your own problem because of the way you define, not you personally, but it's section 113.
Yeah. Yes. So, yes.
It's the implications of what Parliament does. I mean, we're very busy, we can't worry about it. They can look after themselves.
Yeah.
And if they've said it, and if refusing to decide it means they're acting unlawfully, then they've got to decide it. And Parliament has also said, and if you do, there's an appeal.
Indeed. So
this is entirely in Parliament's hands.
Absolutely, but the question
Depends on what's meant by deciding it. And you say, if you decide it's not capable of engaging it, that's not a decision on the substance. And we have to make our own minds up on the facts of this case as to what that means.
Yes. Now, in deciding what Parliament intended, which is the ultimate question for Milady and Milords, these consequences are relevant.
Yeah.
The question is whether Parliament would have intended for this outcome that Milady Friend calls for.
Yeah.
And it is, in my submission, just not credible that this is what Parliament would have intended. Capable of are the words that I respectfully invite Milady and Milords to bear in mind.
Yeah.
So the Article 8, one question is whether Article 8 is engaged, to put it simply.
Yeah.
It's very odd if you have a letter that says, yes, I accept you've got a family life, it's not that strong, and the interference is proportionate. You can go off to the tribunal. If it says it's not that strong, so I don't really think it's an interference with an Article 8.1, on this analysis it wouldn't be, because you're not deciding the merits, you're saying the merits don't arise for decision.
The difference is that if you take the view that it is capable of being engaged, and you say that, well, it's not engaged, then you are refusing a human rights claim. But if you say that, well, it's not capable
The situation is one in which you can't even get anywhere near Article 8.
capable of engaging is
a decision that is not capable of being an Article 8.1 interference is not a decision refusing.
That's it. Yes.
Yes.
that is the point. If the decision maker gets it wrong, then the remedy is
Jail.
judicial review. If you reject the submission that I'm seeking to put forward, which of course you're perfectly entitled to, then that would mean, as Milady pointed out in the course of the argument, we are in a position where everything is a human rights claim as long as a person says human rights.
Yeah.
Section 94 does not assist in relation to this question because Section 94 only kicks in where there is a human rights claim
Exactly.
and there is a refusal of a human rights claim.
Exactly. So it begs the question of whether there's a human rights claim in the first place
And whether there's been a refusal.
and whether it's been refused.
So when you will reread page 3 or 4, the decision letter, I would respectfully invite you to bear in mind the words capable of. Capable of, not, the decision isn't that Article 8 is not engaged, the decision is that it's not capable of being engaged.
And just to remind me, because I'm losing the will to live on a hot afternoon, is it still common ground? Has it never been common ground that there was a human rights claim made, even though it might in your submission have been misconceived run because it was not capable of replying?
Yes. So
It was a human rights claim.
no. So I mean, but what I accept is that there was a claim that was made by the applicant, by FA, saying that there would be a breach of Article 8 if she's not allotted entry clearance.
On the face of it, that meets the test in the statute for being a human rights claim. So the question then is whether that, and the tribunal actually made a finding that it was common ground that a human rights claim had been made.
So
I was reminding myself of this because I looked at the error of law decision and it's made it very clear that it was common ground.
Yes, indeed, and so has the First-Tier Tribunal. But you have the submission that
You can have it. You can have somebody making a human rights claim, but the decision maker can say, notwithstanding you've made a human rights claim, the nature of the claim you're making is not such as to be capable of being a human rights claim. So however you characterise it, it's not actually a human rights claim.
yes.
It's defined as the nature of the assertion. The section 113 defines the human rights claim by reference to what's being asserted.
Yes.
That's the way to use it. Whatever is asserted, it's still open to the Secretary of State to say, well, that's not actually a human rights claim. You're talking about having a family life with your dog, and that's just not within scope.
Yes. Yes.
Yes. Say you sadly had a mental health problem and you thought your spouse was still alive and sadly she died years ago and you wrote in and said, my wife and I want to return to England from France, we want to live together. And you know perfectly well the poor woman's been dead for 10 years. Yes, the husband is making a human rights claim.
Yes.
But is the person refusing it, or is they saying, no, it's
So,
very sad, but you haven't got a wife?
On Miller and Friend's case, the decision maker is refusing
Yeah.
the human rights claim, and the policy is wrong.
Yeah.
On
When-
your case, you're saying it's not capable of being engaged because it could never be engaged in those circumstances.
So
The woman was dead.
when Milady asked the question as to whether this is the implication of the submission that Miller and Friend makes, Miller and Friend very fairly said yes.
Yes, absolutely.
And these, with respect, as Miller and Friend said, are not absurd questions or,
No.
or abstract questions. These questions in my submission are a useful tool to test the submission that is being made. If Miller and Friend is right, all these absurd consequences would arise.
Well,
Uh,
I think you can take it that the court is alive to the consequences if we find that simply by saying you've got a human rights claim, you get your right of appeal, irrespective of what the Home Office does with it.
I'm grateful. So I'll move on to my second point. So you'll recall that Miller and Friend accepts that paragraph 16 of the Upper Tribunal's decision is wrong, but you'll recall but he took you to paragraph 104 of the Upper Tribunal's decision, where the Upper Tribunal says that FA is particularly dependent on the sponsor. There is reference to emotional dependency, financial dependency, and Miller and Friend says, well, that means that the error alleged is immaterial. there are two answers to that point. The first is that the Upper Tribunal took the view that real, effective, and committed sport means dependency. So when the Upper Tribunal said that FA is particularly dependent on the sponsor, this is what it meant.
It's conflating the two, you say.
Exactly. That is the first point. The second point, which is connected to the first point, is that we now know what additional dependence actually entails. Additional dependence means dependence in the sense expressed in Kumari. The court said that categorically, that additional dependence means Kumari. And you have seen Kumari. The court has made it absolutely clear that additional dependence usually means contemplates cohabiting adults, a medical, physical condition that
Complete
incapacitates.
dependence, well, almost complete dependence.
Yes.
They don't go so far as to say it's got to be complete.
It doesn't have to be complete.
It doesn't have
to be. It has to be-
Paragraph that show that it's not complete.
No,
Yeah. So
The Upper Tribunal referred to Kumari.
significant.
It must be your submission that they didn't take it on board in a sense identified in
the reason for that is that immediately after identifying Kumari, in the very next paragraph, paragraph 16, so paragraph 15, they identify Kumari. 16, they say the test is real, effective, committed sports. So that is the second point. The third point concerns a question that my Lord Justice Lewis asked when William Trent was making submissions, whether the purpose and duration are relevant to Article 8.1 question. Miller and Trent said no. The answer on the binding authority in my submission is yes. But what I ask you respectfully to consider is, what is Article 8.1 question? It is not simply whether there is private or family life. It is the question of interference, whether there is interference with the right to respect for family life. But both Lord Justice Sales, as he then was in copy, and Lord Justice Singh in honor of, said that a short visit is unlikely to be an interference with right to respect for family life that does not demonstrate want of respect. So surely that the answer to the question that my Lord Justice Lewis asked is yes. Point 4. Miller and Friend took you to the Secretary of State's policy and showed you, this is tab 24, page 487, where the policy said that if you meet the requirements of the rules, that is relevant to the question of proportionality. And my Lady Justice Henry, you said that, well, if you look at that particular sentence that my lady picked, you don't need to go further. And Miller and Friend, you'll recall, said yes. Miller and Friend has to go further in order to successfully defend the appeal, because the Upper Tribunal did not treat meeting the immigration rules as relevant. It treated it as determinative. The Tribunal said, we are not conducting proportionality exercise at all because this person qualifies as a visitor. Secondly, the policy does not assist with the real question that arises as to who decide whether the requirements of the rules are relevant.
Are met.
Are met, indeed, are met. And Miller and Friend's answer to that point is Huang. Well, Huang says that the tribunal makes relevant findings of fact. No one disputes that. But it is not an authority for the proposition that the tribunal decides whether or not the requirements of the rules are met. And I do, again, when making this point, invite you to consider the implications of the submission that Miller and Friend makes. Miller and Friend says that the tribunal decides whether Appendix V requirements are met, whether a person is a genuine visitor. But when you will look at other Appendix V requirements, there are a number of other requirements. So if for example, you're a student visitor, then you have to meet a requirement if you're studying at a particular level or you're studying medicines, etc. So on Mullenfriend's Mullenfriend's submission, the tribunal decides in every single case whether or not all these requirements are met.
Why are they different from any other fact findings?
Uh,
I mean, you find out whether a student's got enough money in the kitty to keep them going, whether they're studying at a genuine college, etc., etc. That's all is essentially fact finding, isn't it?
It is fact finding. The tribunal is perfectly entitled to conduct fact finding, but the question for the purposes of my appeal is whether the tribunal is right or required to go beyond that fact finding.
Make the legal consequence from the fact finding.
And decide for itself as to whether a person should be allowed entry as a visitor, which this tribunal has done. So if, Milady, the submission that Mullenfriend makes is correct, then that means when a business person applies for leave to remain, and Article 8 is engaged, the tribunal decides whether leave to remain as an entrepreneur should be granted, whether those requirements are met, whether a student meets the requirements, whether a skilled worker meets the relevant requirements. And in my submission, we are back in pre-2014 territory. This is precisely what Parliament intended to avoid by enacting the 2014 Act.
But all this interorum is, I mean, Mr. Shiriko is not saying that in your bog standard student visa application or visitor visa application that you're not outside the usual scope of JR with the decision maker making the decision. I expressly asked him this question and he confirmed it's only where you're within the context of an Article 8 engagement. And so what he says is that once you've got past that threshold and you're dealing with a substantive Article 8 consideration,
Yes.
then all bets are off. I think that's the difference. I mean,
I completely accept, lady, that this is the submission. But take example of a student who has been here in this country for 4 or 5 years.
Yeah.
There's wealth of authority that studies may engage Article 8. So the student would say that, well, Article 8 is at least engaged. I have a private life in this
the
country.
private life claim, yes.
Decide for yourself whether the requirements of the rules are met. A business person would say that, well, I have made some investment. I'm now in this country.
Yeah.
Article 8 is engaged. Well, you tribunal now decide whether I qualify under the immigration rules relating to entrepreneurs.
Going back to another case that you lost, Mr. Manning, in Garland, breach of conditions could only work up to 20 hours, and you worked, I forget how many, 28 or 30. And as you rightly persuaded us, there was a discretion, even if you'd done too many hours, should you be sent back or should you say, well, don't you do that again? And we said that was a discretion. But on this analysis, on Mr. Tarika's analysis, the tribunal would have to say, well, we think they went too far this time. We think he should have another chance. It was only 24 hours.
Yeah.
Technically said it was 26, but it was actually 24.
Yeah.
And we think he should be given another chance. And those decisions would have to be, because again, it would be a breach of Article 8 to remove him into private life halfway through a course. Absolutely.
So if Mullenfriend is right and Singaram makes a human rights claim, then there is no judicial review and the tribunal then gets into the territory of making decisions that Parliament intended it should not make.
So I've written down whether the rules have been properly applied in particular cases, not a matter of appeal, it's a matter of judicial reviews. And for Article 8, it's given the decision that the executive has taken, is that decision a disproportionate interference with Article 8?
Yes.
So the right decision, and if it's not the right decision, it can't be a breach. It isn't compatible with Article 8, it's given the decision they've taken.
Yes, so
Save where Parliament is given to the tribunal, like in Section 117.
yes, so that's how in my submission one distinguishes. He said, my Lord Justice Lewis asked questions about conducive grounds and suitability. Well, I'm glad to tell you, my lords, as perhaps I indicated last time, that they are now not part of Appendix
The
FM.
rules have changed.
No, they have
actually.
changed.
There is now a completely different part suitability. So that problem no longer arises. The final point about return. And Lord Justice Lewis asked whether there was cross-examination. Yes, there was. So when the sponsor was giving oral evidence, her evidence in chief was to the effect that, well, I haven't been to Gaza to see my mother for many years, so I probed into that. Well, why is it that you haven't been to Gaza? She said, well, because of all the problems. And what the problems are, well, I can't go to Gaza. And then the question arose, well, if you can't go to see your mother, if your mother comes to this country, how is it that she will leave? And there was no real answer apart from what Malone friend said, that, well, once she's here, we'll then figure out something to that effect. So the point was put to the witness. She gave an answer. I made the point before the tribunal, and the tribunal was obliged to deal with it. In answer to that, Malone friend takes you to paragraph 306 of the supplementary bundle, a letter that Malone friend's instructing solicitors sent to GLD on 14th of May. Now, the court, in my submission, should not look at that letter at all, for a number of reasons, and I must identify those reasons. I know it's past 4:30. The first reason is that letter refers to parliamentary statements and debates and a witness statement made in other litigation. Now, those parliamentary statements and that witness statement was the subject of the application notice that was made earlier this week, which wasn't pursued for good reason. There are issues about privilege, parliamentary privilege, prejudice. This wasn't before the Upper Tribunal, so Ladd and Marshall comes in, etc. So, but it isn't, in my submission, appropriate to look at that letter.
It doesn't help anyway, Mr. Malik.
No, and the second problem is that Malone has shown you a letter that was sent by instructing solicitors to GLD, but there was a response from GLD saying that, well, you've got it all wrong. This isn't our policy. This isn't our policy. We were not encouraging medical visit visa applications. When we were granting leave to remain, that was leave outside the immigration rules, and you haven't seen that letter. Well, if you wish, that letter can be provided, but it wouldn't be appropriate in my submission to simply look at that letter and give any weight to it. I'm very grateful. So these are my 5 points in reply.
May I just respond to that? I'm sorry, I realise how long we've gone, but the reason that letter's not before you is because the Secretary of State refused to allow us to put it before you. That's why. It was part of, we asked to be able to put that for you so that you could see the Secretary of State's response. So I think that's an unfair point to be taken. It's the reason you don't have it is not because we tried to stop you looking at it. I need to say that on behalf of those behind me. Of course.
Yeah. No criticism from that. I wasn't suggesting at all that is what was being.
I doubt if it's going to make a great deal of difference to the outcome of this case one way or the other, but we have your respective points on it. Thank you to both leading counsel and to those behind them, and to all their legal teams for the enormous amount of hard work, and also thank you for the goodwill displayed towards us in the light of the Vice President's sudden indisposition, and for putting up with us trying to truncate this. I'm sorry, Mr. Chirico, it rather sort of affected you, I think perhaps more than Mr. Malik in terms of the time that you would have liked, but we are very grateful. We will reread, of course, the skeleton arguments and think about it all very carefully. It's an interesting case. It won't come as any surprise to know that we will reserve our judgments. We'll hand down the drafts in the usual way. There will be no need to attend. We'd hope that you might be able to agree an order and anything consequential. If you need more time for that, just let us know. And the usual embargo applies. I think with counsel of this calibre, I don't need to remind you about the importance of strictness of confidentiality. Thank you very much, all of you.